Hello everyone, welcome to ShailajaIAS. This is Subhash and welcome to the PYQ Decoder class where you get the edge for the prelims and you will be able to knock the 2026 prelims. So in the previous classes we were discussing polity themes. In this class we will continue with the polity themes. Here we will discuss about polity, state government, state executive, that is the governor, the judicial system where questions have come. This is also one of the important key units where important micro themes has picked and questions have been asked from. We'll see. I have covered last 5 to 6 years. You can do last 20-25 years and check the themes and understand how the questions have been set, how the traps have been set, how logically you can deduce the answer. We'll start. So 2025 question. Statement 1. The Constitution explicitly mentions spheres where governor acts in discretion. Normally Constitution defines, Constitution mentions, okay, Constitution classifies will be wrong, but he's telling Constitution is explicitly mentioning, not defining, mentioning that governors have discretionary power. In the last class, with respect to discretionary powers of president versus governor, I was talking about, had mentioned that governor has discretionary power mentioned in Article 163. Article 163 subclass 3 and subclass 4 mentions that any subject which governor thinks that it is fit to have his discretion, he can do so. Does the article Constitution mention which are all the subject governor has discretionary power? No. It mentions that governor has the discretionary power with respect to the subject that he deems fit for his discretion to be exercised. Whatever subject he thinks that it is fit to be exercised under the discretion of governor, he can take it upon. The subjects is not mentioned in the article. However, it mentions the discretionary power that has been assigned under Article 163 in the Constitution. So this statement is right. Statement 2. President can of his own reserve a bill passed by state legislature for consideration. What's happening here? State passed the bill and it's with governor. So Article 200 deals with what governor can do. One of the option is he can send it to president. And what president can do with the state bills, it is mentioned in Article 201 of the Constitution of India. Here the statement saying president can on his own reserve a bill passed by state legislature. Can he bypass the governor and take the bill passed by state legislature? No. Only if governor passes the bill for the consideration of the president, then he can accept it. There is no bypassing. But once the bill is sent to president, governor's relation with the bill gets cut and the bill is directly dealt if it is returned back again to the president assent itself. So this statement is wrong. Conceptual clarity, analytical mind is very important while solving the questions of UPSC. So statement 1 is right, statement 2 is wrong. Okay, only one first pair. Okay, the first statement is correct. We'll go to the next question. Governor and immunity. With respect to criminal, with respect to civil, and immunity of the members. It might be parliament members or state legislative. Immunity is one of the key themes and also it is in news for one or the other reasons, maybe due to Supreme Court's judgment, due to ruckus in parliament or state legislative assembly. Immunity provided to the members are in news. And the judgments with respect to that immunity which were given also will be very important. Those themes, those judgments, you have to go through make the notes, okay, understand the traps, and those questions are very likely to get repeated from those areas. Governor is not answerable for any code for the official duties of office. So do the president, right? For whatever acts he has done is not answerable in the office with respect to duties of the official capacity or the office duty, correct? No criminal proceedings instituted against governor during his term of office. Okay? No criminal proceedings can be instituted, correct? For civil, please answer in the comment section. Member of the state legislature not liable for anything said in the house, correct? To protect freedom of speech and expression and to express freely, there has been an immunity for the member of state legislature. What are the articles given? Mention what are the articles in the parliament. So, need not by heart, as I am telling, the conceptual clarity and the understanding. So here all the three statements stand right. So 1, 2, 3 are correct. All the three pairs or three statements are correct. What is important is with respect to this, what are the Supreme Court recent judgments, which case, very important. Same with respect to president, very important. Which are the articles, immunity, criminal immunity, civil immunity, official acts immunity, okay? All these are very important, which might get repeated again in the next PYQ, next year prelims. Okay, this is Panchayats, which is a part of prelims syllabus, is speaking about intermediary level. There are generally 3 levels, right? Grama Panchayat, Taluk Panchayat and Zilla Panchayat. So Taluk Panchayat, the question has been asked in 2025. Which of the following statements are not correct? Sir, please see the trap. Sir and ma'am, not correct. It exists in all states? No. Only if the population is more than 20 lakh, then it might be, if not required, if it is less than 20 lakhs. Eligible members' age is 30 years. Okay, for Panchayats it is 21 years. For a Lok Sabha it is 25 years. For a Rajya Sabha it is 30 years. How much for the governor president? Please comment. So it is not 30 years. This is also not correct, so right. This is also not correct, so right. Statement 3, CM constitutes a commission to review financial position. There is a state finance commission, right? For Panchayats. Okay, which constitutional amendment? Which are the acts? Okay, 73rd, 74th Amendment Acts, right? Does CM constitutes or governor constitutes? Typical authority swap, the trap. CM will not constitute, right? Governor will constitute a commission. So all 3 are wrong. He has asked which is not correct. All 3 are not correct. So answer will be D here. 1, 2, 3. All the 3 statements are not correct, my dear friends. Understood? 2025. We'll not say not correct. We'll say all 3 are wrong. Okay? If none of the above option is given, we'll go with none of the above. That mistake you please don't do in the examination hall after getting the answer. Next, scheduled tribe in states. 5th schedule, very important. 6th schedule, very important. The relation of governor, the government and the president, very important. 5th schedule, 6th schedule, special powers or special privileges given under Article 371 are repeated themes, my friends. Please go through this again and again with clarity. You have to understand the concept, what all powers, functions, president does, governor does, the government have, the limitations you need to understand. So we'll see now with respect to scheduled tribes in state. Governor recognizes and declares community as ST in a state. The typical authority swap. President only can, under Article 342, give scheduled caste, scheduled tribe. Only for the backward classes in a state, governor can take a call for each state. The central OBC again will be resting with president. The authority swap. So governor will not recognize and declare a community as ST even in a state. It is under Article 342 for president. SC and ST. Central OBC also president. Only state OBCs governor can decide. So this is wrong. The authority swap, which has been asked in 2024. Community declared ST in one state may not be so in another, which is right. Okay. Need not be a rule that community which is a tribe in one state may not be a tribe or scheduled tribe in other state. So this is right. Answer is one only, which is second statement. Clear? Next question. Management of prisons. Okay. Under state government as well as judiciary it comes, as well as the subjects. Okay. The schedule. The 7th schedule subject. Very important. One question might come, which are the union subject, which is the state subject, which is the concurrent subject. Please go through. Prisons managed by state government with own rules. Police, law and order, prisons are a state subject. Therefore, this statement is logically correct. Governed by Prisons Act 1894 before independence. Okay, Colonial Act, which kept subject in control of provincial government. Correct. Police was a subject in provincial government, which logically was transferred once independence got. The state had the police, prisons, law and order, management, okay, under state subject. So 1, 2 is logically following logical 1. So both the statements are correct. And this is a statement based question. Yes, both are correct. And statement 2 is the right explanation for statement 1. Hence, option A. These are statement based questions. So, answer is option A. Statement 1 is right. Statement 2 is right. Statement 2 is logically following the statement 1. Next, writs. Okay. Fundamental rights. To get real meaning, Article 32 is very important. It is the soul, right? Dr. B.R. Ambedkar mentioned it, right? Soul of the Constitution. How many writs are there? Okay. The important 5 writs you have to know. Habeas corpus. Okay. Mandamus. Prohibition. Quo warranto. All this you need to know. Which bodies it will apply, you have to know. One question might pop up from this area. A writ of prohibition is an order issued by Supreme Court or High Court to where it is an issued to the lower court prohibiting that you are crossing the line, your constitutional limit. So lower court prohibiting the continuation of any case if it has taken and if it is crossing the constitutional limit. Direct. Okay, if you know the proper writs and its definitions and to which bodies it applies, it's enough. This is what UPSC is asking in this section. Now, Attorney General is a state executive and Solicitor General. Which is mentioned in the Constitution and which is not mentioned in the Constitution? Guys, please comment. AG is mentioned in the Constitution. Solicitor General is a statutory body. Right, statutory body under Act. So, AG and Solicitor General, Attorney General or Advocate General or in the state, here it is in center, Attorney General and Solicitor General are the only officers allowed to participate in parliamentary meeting. Attorney General, constitutional body is allowed and it is mentioned in the Constitution. Solicitor General, it is not allowed. So statement 1 is wrong. AG has the right to participate under Article 88, which is a constitutional body, Attorney General office. According to Constitution, AG submits resignation when government resigns. Is it completely true? AG has security of tenure? Does AG have security of tenure? No, he does not. He will work on pleasure of President. And if President, aided by Council of Ministers, government says resign, he should resign anytime. So, AG submits resignation when government resigns, need not be. Okay, if the incoming government wants this AG to continue, he might carry on. So statement 2 is wrong. So neither 1 nor 2. The tenure is linked to the pleasure of President. So Constitution does not mandate resignation. AG holds office during President's pleasure. Clear? So both statements are wrong. Have the clarity, understand the trap set, go through each questions of last 25-30, follow my theme, make a journal. I'm sure that you guys will have the heads and clear prelims, okay, and get that path ticket to the mains. Next, contempt of court, okay, contempt by members and contempt by, if the contempt has happened, ethics committee, okay, other committees, dispelling of the members which has been in the news, are also themes which are repeating again and in news linked to static subject that you have to also focus on. Contempt of court, we'll see. 1971 Act passed via H.N. Sanyal Committee. Okay, history and committee linked with static subject. 1971 Act passed via H.N. Sanyal Committee. Yes, it is correct. If you had studied, if you know, you can answer. Otherwise, it is a bit difficult. This is tricky. If you have known H.N. Sanyal Committee, you can answer. Supreme Court, High Court, empowered to punish for contempt. Correct. Contempt. Constitution defines which are the different types of contempt. Contempt, criminal and civil. No, Constitution does not define. Parliament can make law on contempt. Yes, Parliament can make law on contempt. 1971 Act is there. So Parliament can make. Statement 3 is wrong. 1, 2, 4 are right. So 3 pairs, 1, 2, 4 are the right options. Clear? Very important thing. Linked. See the linking with committees. Okay. Judiciary with what Parliament can does in those contempt of court. Is it defined? What are, if is contempt defined? Which is the act that defines the contempt? Which are the types of contempt? Okay, which was in news. Please go through. Again, writs in India. 22 question. Mandamus, not lie against private unless public duty. Okay, correct. Only if the private body is performing public function, then it is included. Mandamus. Mandamus not lie against government company. Nothing like that. Okay. Mandamus can lie against a government company if it is performing public function. Public minded person can be petitioner for quo warranto. Quo warranto need not be agreed person. Any person can file petition for quo warranto. By what authority? By what authority is sitting in that public office can be done. Does not require petitioner who is aggrieved. So 1 and 3, 2 pairs are right. Which option? Option C. C. Judiciary to Supreme Court, High Court, removal of judges. Okay, these are the key themes, key areas or questions are coming again and again. Lawyers, Advocate General, Attorney General are also the themes. Next, Advocates and Bar Council. The bodies linked with judiciary, linked with mechanism and functions of judiciary, which is lawyers, police, Okay, all this forms the entire network of judiciary. Government law officers recognized as advocates, however, corporate lawyers are excluded. This is wrong. If you know it, the statement, you can answer. If not, it is bit difficult. Who are advocates, who are not advocates? You should know the definition of advocates and recognition that happens in Bar Council of India. Bar Council, okay, powers to lay down the rules for legal education. True. And Bar Council of India is a statutory body under Act, and it has the power to lay down the rules and to give, okay, membership for the lawyers and advocates. And you have to know the statement first, and statement 2 is right. So first statement, corporate lawyers are also advocates, so only second one is right here. Understand how UPSC is going, which themes it is covering, how network it is building. Through that you can understand and revise, go through and be able to answer. Few will be tough. Out of 15 you might not be able to get all 15, 16 right. But if you can reduce the mistakes and if you can increase from 8, 10 rights to 13, 14 right, that is also an achievement. Even 1, 2 question right might make a break or lose in the prelims. So important, go through all the themes, give weightage properly, revise in the order, okay, connect the themes and multiply revise and make a journal of the PYQ, the traps, and deduce logically. This respect to judiciary, retired Supreme Court judge can be called back by CJI with President's permission. Correct? Okay. Temporary Supreme Court judges, if there is a shortage, or additional judges if required, what can be done? Can be called back by CJI with President's permission. Correct. High Court power to review own judgment as Supreme Court does. There was a dispute. Okay. This under Article 215, High Court also are court of order and can it review its own judgment as Supreme Court does. Normally, this is right. Article 215, based on that it can do. But Supreme Court's court of order is different mentioned with respect to High Court. So, UPSC answer was option A, only one is right. However, High Court also has the power of review. In the wording, there was a game, but you know that High Court under Article 215 has power to review its own judgment like Supreme Court has. So, we can go with A or both 1 and 2 here with respect to court of, okay, court of record and power to review its own judgment. Judicial custody, right? Then place the news, okay, the current affairs linked with your knowledge to apply your static polity. Accused in custody of magistrate, that is court magistrate, is locked up in police station. Is it? There are two custodies, right? One is police custody, one is judicial custody. When you are arrested, court will give permission for you, if you are a police, to take to police custody for 14 days or 21 days, whatever days is required. Accused in custody of magistrate will be locked up in police station? No, you will be under judicial custody, under magistrate. You will not be in police custody. Unless police requests to police custody and takes the accused person, the custody of magistrate will always be in judicial custody. Jail warden will be taking care of the accused person. He will be in judicial custody. Statement 1 is wrong. Police not allowed to interrogate without court approval. If you have to interrogate, even if you have to go to judicial custody and interrogate also, you need the magistrate's permission. Once he goes from police custody to judicial custody, he needs the permission of magistrate and is not allowed to interrogate without the court approval. Statement 2 is right, statement 1 is wrong. So here option B. Okay, accused is in jail under magistrate control. So is in judicial custody, not police custody. So statement 1 is wrong, statement 2 is right. Only one pair is right here. Clear? So these are the few questions that have come in last 4-5 years, but questions has been coming with respect to strength of judges, with respect to removal of Supreme Court and High Court judges, with respect to NJSC, right, which was struck down by Supreme Court, with respect to separation of power, independence of judiciary. So please focus on all these micro themes in judiciary, in state government, the fight between the state government and central government for administrative power, for financial devolution. So these are also important areas where questions are coming from. So please revise those topics also. So here, with respect to state government, in the last 5-6 years questions where has come, state executive, judiciary completes, go through for the more years, understand the themes, understand the statements, try to logically deduce, don't see options, don't see how much marks I got, how much questions got right or wrong. See the statements, even options holds key for the future questions that might come in Prelims 2026. That saying, we'll meet you in the next class with next themes which are very important in the polity. Take care, see you.